Should I just yell? All right. Okay, I am pinch hitting here, so I'm going to do my best, and I'll have my colleagues correct me if I mess anything up here. It used to be, back in the day, that the Chapter 30 program of the department, Navigable Waters Group, those are the water management specialists, would be involved in mining pretty regularly. And that was because they covered mining basically on the bank or grading on the bank. They would cover anybody who wanted to do a dredging project and mine material out of a river or stream, that kind of thing, or change a water course because they wanted to mine out gravel. As most of you old sand and gravel guys know, the best place for that stuff is right next to the stream or in the stream. So anyway, I'm going to talk a little bit about navigable waters. A lot of the jurisdictional stuff has changed recently due to some legislative action, and we'll talk a little bit about that, and also the wetland stuff that's pretty hot off the press. So when it comes to mining, some of the more common things that we'll run into which will require additional permitting on your end would be ponds within 500 feet of a navigable waterway, stream realignments, dredging, and all three of those things, or those three activities, would kick you into NR 340, which is the non-metallic mining code. So essentially those state stats, or Chapter 30, bumps you into needing to comply with NR 340, and I'll talk about some specifics of that in a little bit. All of this comes also off of the, I'm sorry, I need to talk about wetlands too. Any department regulates the discharge of fill into wetlands, and so that's the other thing that we would be referencing through this process. Always holding everything up to NR 103. So here's some of the specifics of Chapter 3019. Anytime anybody wants to construct, dredge, enlarge any artificial water body that connects with a navigable waterway, this is a connected enlargement essentially, or the construction of a pond or a waterway that is within 500 feet of a waterway, an enlargement via dredging, or grading in excess of 10,000 square feet on the bank. That last one is has changed, and I'll talk about that in just a minute. That's right now. So the grading thing went away. That's this point number 4 down here. That used to require that you go through this non-metallic mining non-metallic reclamation permit through the state. Now it's handled, essentially covered by any land grading activity that's covered under a stormwater permit, which is the one I talked about before, or anything issued by county zoning. So let me just summarize that real quick. Any grading on the bank is covered, or if grading on the bank is covered either by a stormwater permit or by county shoreline zoning, you do not need to go through this Chapter 30 NR 340 process. For dredging, Chapter 3020 requires permits to remove material from the bed of a navigable waterway. I'm unaware of any permits to mine in a navigable waterway that I don't know if they get issued anymore. 30.195 requires permits to change the course of a navigable stream or straighten a navigable stream. We're not doing those very often either anymore. Wetland permitting, this is a joint activity through us and the Corps of Engineers. They're required anytime you want to discharge material into wetlands. The Corps defines discharge as physically place, whereas in the water programs we talk about discharges of water that may contain sediment. But for the purposes of this permit, let's talk about physically placing sediment or soil into wetlands. So a permit's needed for that. You have to consider practical alternatives, minimize impacts, no significant adverse impacts to wetland functional values. That's that NR 103 business. And you have to also discuss and include information on cumulative and/or secondary impacts. Secondary impacts are hydrology, So you've got an isolated wetland and you want to dig all the way around it and take out sand and gravel, there probably isn't going to be a wetland there anymore. So we also look at secondary impacts potentially. And then ultimately we can get into mitigation. NR 340 is the part that regulates reclamation. And this is the question that Buck asked me 45 minutes ago. Both the department and the counties share responsibilities for getting mining sites reclaimed. The counties do it under the auspices of NR 135. They require annual permitting or permit fees. They require bonding and all that kind of thing so that when somebody's done mining out a deposit, they don't walk away and the site's left as a moonscape. A reclamation plan is filed with the county, and there may be Board of Adjustment approval, conditional use, whatever approvals might be necessary. And ultimately, if the operator walks away from the site, the county, via that bond, theoretically has the money to go back and reclaim that site. The department has the same responsibilities if there's a permit granted within that 500-foot line. The nuance has always been for folks that are sort of in this boat of, hey, part of my mine is within 500 feet and the rest of it's not, so who has authority? And unfortunately, right now, the answer is both the DNR and the county. So you fall essentially under, you have two reclamation permits, one under NR 340 with the state and one with the county for everything else. There's been efforts to change that. Time will tell, I guess, on that. So the NR 340 business, and this is the part within 500 feet typically, because we're concerned about runoff from these things and other things. So it recognizes the sensitivity of the lake or stream and the immediate banks, and the hope is to mitigate potential harm. Avoiding excavation in channels or banks where alternatives are available. Having the applicant demonstrate that excavation is technologically or technically, economically, and environmentally feasible. Extra protection for ORW and ERWs, and some other application things. Let me just, one of the nuances with the NR 340 permit that makes people excited sometimes is the requirement to allow public access. If a pond is constructed within 500 feet of a navigable waterway and is ultimately reclaimed to a pond in the floodplain, that entity or landowner has to provide public access from the nearest water resource. So you put a pond 300 feet away from a river, typically a larger river that could potentially flood, and deposit a public resource, fish, aquatic life, in that pond. You have to provide public access. It has to be deeded at the courthouse. There has to be a sign on the river to allow that access. It can sometimes be a deal breaker for a property owner to do that, obviously. The way out of that, though, is simply don't reclaim into a pond when you're done. Just fill it in. So.
Brad, what if you have a situation where you take the material, the gravel, out of that particular area, but then you fill it back in with waste material? Is that something then that you wouldn't have public access?
Correct, yeah. So you would still have to maintain the NR 340 permit for the life of the project, but if you reclaimed to a point where you didn't have any water, you had no pond within 500 feet anymore, you would no longer have need for the permit, and therefore you would not need to have public access anymore.
But what about during the time that you're operating, if you've got a mining operation, when you're mining underneath the groundwater table? Would it still be open? Would you have to open that to the public at that time?
No, public access isn't required until reclamation is done.
So only after it's reclaimed, so on ongoing it wouldn't be open because you wouldn't want people
Correct.
Fishing and getting sucked into your dredge, obviously.
Correct. Definitely. All right, so some of the stuff that we would require in permit applications for this stuff, pretty typical soils information, where are the water resources, how high is groundwater, the usual ARC historic, endangered and threatened resources. We'd want reclamation, obviously, whether there's any other permits. If there are wetland activities that are proposed, we want to know about other alternatives. These are some, this is a pirated presentation, so this is High Crush down in, I think, Wyville. Just some real basic pictures of them. Yeah, Jim.
They come to explain that the chapter 30 permit would only be required if it's a wet pond. If it's a dry pond, it wouldn't fall into that.
Why don't you elaborate on that one?
The way I understand it, the way it's been interpreted in my area anyway, is that if that's a dry pond within 500 feet, so it's just for bounds, not having as much TSS, although there may be some type of a meter discharge or something, it wouldn't require a chapter 30 permit, so it wouldn't fall under our regulation for reclamation. If it's a wet pond, if it's defined wet pond, it's going to set wet all the time, and it's within 500 feet of navigable water, then it's required a chapter 30.
Yes, I agree with that. So the nuance is, if you have a spot that you call a stormwater pond and it accepts stormwater and may or may not ultimately discharge, but ultimately goes dry, we would not consider that a pond needing permit coverage under Chapter 30. Right? Okay, got it. I'm trying to think at High Crush, and Shen is here. I don't think there were any Chapter 30 issues, were there? Did you have any? So I'm not even sure why these are in here, but it's a neat site, so here you go. There's some more pictures later. One of the requirements that I talked about real briefly was financial assurance. That's so that reclamation gets done if the owner decides to walk away. We have the same, I'm not sure if our math is the same ones that the counties use or not, but the goal is to be able to 100% be able to reclaim the site into a usable condition when it's all done. So we pretty much take any kind of money, performance bond, CD, irrevocable letter of credit, trust, escrow, all that kind of stuff.
Brad, so that what you're saying, is this what DNR uses everywhere in the state, or is it site specific?
No. Oh, actually, I'm not sure about that, Buck.
One of the confusions that the industry have on this is that you might have a Chapter 30 bond with the DNR, and then you have a different bond with the county or whoever's the certified agency. And they may be, one might be 3,000, one might be 4,000.
I think they vary, yeah. Because of the site, you think about some of the high wall stuff in limestone country where you're going to try to reclaim a high wall versus a flat farm field or something like that.
Yeah, but does DNR use the same as the county uses?
No.
No, the county set their own.
So it's very feasible then you might have one bond that requires 4,000 an acre, one that requires 5,000 or whatever, making up numbers. But
Yes.
Yes.
And
not very logical, by the way.
No.
That's fair, that are
And I'm not aware of us, DNR, going in to reclaim a site. I do know that Marathon County has reclaimed a site after the owner walked away or declared bankruptcy, so it does happen. This is just performance bond language. We issue a permit if we determine that it's not detrimental to the public interest, will not cause environmental pollution. And nobody will be harmed through the actions of the operation. The permits are good for 10 years. They need to be updated as applicable. They need to let us know as changes happen in the plans. Stockpiling has to be done in accordance with shoreline zoning. This is one of the public access documents. It's the one, it says down, oops. What did I do? Oops. Struggling. All right. Anyway, talks about a 30-foot wide easement down at the bottom. More pictures of sand operation. Yeah, you can see somebody's hat down there. Just some processing equipment. I think I'm almost done. Done. So, that was a very, very brief Chapter 30 explanation. Let me talk a little bit about wetlands. The wetland laws have changed recently. There's a general permit that allows the filling of wetlands up to 10,000 square feet. Please talk to us before you just go ahead and do that. That activity is only allowed under a general permit, so there still is a permit requirement to do that. Any proposal to fill over 10,000 square feet of wetlands requires an individual permit, which ultimately leads to a mitigation process where there would have to be compensation for the loss of those wetlands. One other thing to keep in mind with the wetland thing, that there still is a requirement if there's a proposal to fill wetlands to avoid first, minimize second, and then we move on with the process. So we'll still, go through those processes of trying to figure out whether you can avoid, minimize, and then we move on with the permit process. So that's what I have for wetlands. Bob?
Question on that, avoid, minimize, and it's similar to the practical alternative analysis that we've had.
It is.
It's just a different language that you're using. And the problem with that from the industry point of view is whatever you guys want it to be. And so even though you have that, and you have, the intent was to make it easier for 10,000, not just fill automatically, but to make it a little easier. And yet, the consistency of some of the people throughout the state of Wisconsin working at DNR is not always consistent on that. And we're seeing that on a few sites. I don't know if you want to comment on that or not.
I don't.
Don't let Deb do that.
Yeah. Thank you.
No, it's still frustrating from the industry point of view, is the point I want to make, because you got this for 10,000, and the idea behind it in the legislature was if it's going to cost the project $50,000 or another $100,000 worth of cost, the idea was to have a general permit so you could fill that small area. Yet some people are still reluctant to say that you haven't done anything. You can build a apartment building with 50 units instead of 100, even though you're not going to make as much money, and it's not economically feasible under those conditions. So it's a benefit, but it's not the complete solution, I guess, is my comment.
I don't have a lot to say about that, to be honest. My suspicion is that there isn't the kind of guidance out of Madison on how to implement this thing, but I don't know for sure. So.
One comment, if you get into the...
That's not enough.
Thanks. If you do get into the mitigation process, realize the mitigation, the bank is broke. There's not a lot of sites out there to mitigate with, so don't go into it thinking it's going to be easy to mitigate, because there's not much in the bank right now. There's some being developed, but pretty broke.
And mitigation costs are $30,000 to $40,000 an acre, roughly.
Yeah, but DNR is working on what's called a fee in lieu of mitigation. That isn't done yet, but the idea behind that is that, similar to the program we talked about earlier today, is that they can come up with an area similar to the butterfly, and except it's 1.25 to 1 on your wetland mitigation. It'll allow mitigation, allow a fee to be paid, so that DNR then will be able to go out and build some larger one. And part of that is they don't have enough banks right now. It takes a while to get banks developed. But from the industry, there's a lot of these operations that might be ideal. wetland banking sites, if you've got some areas that are, you can break some tiles, you can do some things. You gotta find them that are economically feasible to make money on doing that. There is a lot of requirements on it, and also a lot of work that has to be done, a lot of monitoring. But it's a good program, but as you stated, there's right now the bank, there is one that's got a few credits left, but and some of them are still available for DOT projects, but for the mitigation itself, there's nothing out there right now, which is a problem.
Yes?
Can you further define navigable water?
Yeah.
Did everyone hear that? He's gonna, Brad's gonna give us the ultimate definition of navigable waterways.
All right. It's real easy. It has to have a bed, it has to have a bank, and then it also has to be able to float a craft of the shallowest draft once per year.
And DNR typically will take the smallest person that they have at DNR, and they'll take the smallest boat too.
Yeah, we're not taking Buck out in a boat.
But what is that?
Somebody small.
I tried that, it didn't work. Yeah, but if you want to have some fun, find an area that has so many trees over it, they have to take their chainsaw. Then they need somebody big like me to go in the mold. You might be able to get a better result.
Yes?
The Army Corps of Engineers has authorities regarding navigable waterways. So how do you coordinate with the Corps? The Army Corps of Engineers has authorities regarding navigable waterways. My question is, how do you coordinate and what do you coordinate with the Corps regarding navigable waterways?
Let me answer a question you didn't ask first. We coordinate with them very well on the wetland stuff. We have a combination permit that we work through with them together every time. When it comes to navigable or projects on navigable waterways, we also coordinate with them very well. The nuance is we don't get very many projects that are proposing work in navigable waterways. So the coordination is there, but it's so infrequent when it comes to those projects because we just don't have them.
Any other questions? If not, thank you, Brad.
Thank you.
Now the last speaker is going to be Deb Dix, and we're going to talk about enforcement. So she's going to talk about step enforcement, and everything you learned today, if you do everything that everyone told you today, you're never going to have to deal with enforcement because all your permits are going to be in order. Now that sometimes is a little bit out of your control. Sometimes things happen and you end up in an enforcement conference. Deb is going to tell you, and a lot of times when you get the lawyers involved in the enforcement conference, it's way too late. Your opportunity really is to work with the DNR staff at the notice of non-compliance stage, at the notice of violation stage. Deb will tell you how to do that. But the best thing to do is make your record. You've heard a lot of things today. You've heard about yearly documentation. In the winter, after you've got everything shut down at your quarry, get those paperwork out and file those reports. Even if you don't think you have to file them, write a letter to Brad and say, we've expanded, but where we haven't operated this pit, nothing has to be done. Having that record if something goes wrong is a very, very important document that can keep you out of jail, your get out of jail card. So try to do that as much as you can, but just in case you still screw up, Deb's going to tell you everything about enforcement. Yeah.
Before I get started, I'd first like to thank Buck and then Paul Millis, the two firms, for making this possible today. If it wasn't for them, we wouldn't be here. And we appreciate the opportunity to share information as much as possible and get it out there. Contrary to popular belief, it is not our goal to get you into enforcement. We would rather see you be compliant and everything go well. So to do that, let's see what we can do here. The first thing is we've talked about a number of different agencies. We got counties here. There was questions about the Army Corps of Engineers. We try to work together with all of the agencies involved that regulate, try to coordinate and make things simpler as possible. Proper planning, communication. I cannot stress enough communication. We're not scary. We're here to help you. And the more you ask questions, the more we're able to help. The field staff love to have questions and be able to answer them. It makes their life easier if they do it up front than to have to go and try to resolve things after there's problems out there. So planning ahead, keeping communicating, that's going to minimize your conversations with folks like me. It also is going to stop project delays. It's going to reduce your after-the-fact fees for doing something before getting your permits. And then, of course, generally, if you have an enforcement history, that just creates and builds to the point that we end up at DOJ, or if you're dealing with Army Corps of Engineers, you can be looking at the federal DOJ. So those are places you don't want to go. Communication up front is going to help to reduce that. So from the environmental enforcement standpoint, we really don't like to see things like this. Have somebody who's out walking a beautiful path find this heavy sediment stream coming down and eventually getting into a very critical water body. We'd like to stop things before they get to this point. Our first steps when we start working with facilities that are your informal contacts. That's working with folks like Roberta and Brad and Jim and Dave Johnson and getting out there and talking to them first, finding out what the regulations are. If you think you did something that maybe you shouldn't have, stop, call them, talk to them. If you don't know who to talk to, just call whatever is your closest DNR office, and they're going to get you in touch with the right people. Document. Always document what's going on. Buck just said it. Document the steps that you take along the way. If you're taking daily readings, if you have a rain event and you've got some runoff, document what's going on, because a lot of times we get calls from the public and we hear their version, but if you've got documentation and photos of what happened, that gets taken into consideration too. So always keep your own documentation. Invite your DNR staff to pre-construction or planning implementation meetings. If you're just getting started and want to have the right things to do, get us involved early. The environmental enforcement process, we generally start out pretty informal, but it gets more formal and legal as the steps progress. We go through what is called a stepped enforcement process, which I'll get into a little bit more. But in 2010, we had statewide civil actions, 461 notices of violations, 232 enforcement conferences, and 51 cases that were referred to the Department of Justice. Averaging off, and I'm not going to read those numbers to you, you can see they can get pretty substantial, and those will kind of go up and down over the years. So the process, again, informal contacts, that's with your field staff, your local folks. Hopefully you can keep it at that. The notice of noncompliance is the next step. That generally comes from your field staff, and that's where they're going to let you know that you have a problem. You've got violations, you need to correct them, and they're going to explain to you what corrections need to be done and give you some timelines to try to get things taken care of. If it doesn't happen at that level, they put out a secondary enforcement request, which then gets us involved. We're going to come in. We're going to do the notice of violation. This steps it up to where we're going to give you the actual statutory language, which tells you what your potential monetary forfeitures could be. We're also going to, generally at the same time, invite you in for an enforcement conference. That's our opportunity to sit down face to face and get your version of what happened, talk through everything, and let's see if we can resolve it at that point. What I'd like to interject here is we can shift between these steps at any time. So if we have an egregious situation that occurs and you've not received a notice of noncompliance previously, we can go right to that notice of violation and enforcement conference. We can go directly to Department of Justice if we need to try to get an injunction to stop work. So we can skip between steps depending on the severity of the situation.
Once you get to the Department of Justice, though, you can't really take it back at that stage.
Correct. Once it goes to Department of Justice, it cannot go back unless they would, for some reason, reject the case that they did not feel that it should have been brought to that step in the first place, which I've seen happen a couple of times, but not very often. We have administrative orders and consent orders. These are used, the difference being administrative order is an order that we're going to write, and we're going to set out specific steps and timelines that you need to meet for resolving the violations that have occurred. We're going to be telling you these are the things that you need to do. This is an enforceable document. A consent order is written very similarly, but it's agreed upon steps. So you actually are going to sign the order and say, yes, I agree to do these steps. Still an enforceable document, but it's your agreement that you're going to do the work. We have the ability to refer to Department of Justice, sometimes to the local district attorney, and some instances EPA. We can also write citations in certain instances. Brad mentioned one of the cases where we did write citations on a discharge to a water body. So the notice of noncompliance, again, is issued by program staff. It's sent to the violator, and this is all repetitive, I guess. There's a program decision that's based on the seriousness of the violations, whether it's not going to be bumped up to the notice of violation. We go through an environmental enforcement request form, which is what they fill out that sends it to us to actually request advanced enforcement. We're going to look at it and say, well, yeah, based on the information you've given us, it's time to bump it up to the next step. Or if it looks like there's not enough proof, we're going to drop it back down to them and work with the staff to try to resolve it at that level before it bumps up. We review for consistency. Again, proof of the violations. One of the things that we very specifically have to do within the statute, within the laws, there's certain proofs, things that we have to be able to prove, such as it was a permit violation, that you had a permit that could be violated. We have to prove that it was a discharge to a waters of the state. So we have to be able to prove those things to move it up for advanced enforcement. So we're not just looking at it and say, yeah, we think you had a really bad discharge and we're just going to prosecute for that. We cannot just do that without having the proof that it happened. The notice of violation is a formal letter. It comes from folks like Ginger and I, who are your environmental enforcement staff. It's going to state your violations, permit, statute, code, very specifically what it was. It's going to give a description of the violation. It's going to warn you of your potential for prosecution and penalties. And it's going to request information that you provide within a set period of time, or in a lot of cases, ask that you bring it with you to the enforcement conference. If it's a governmental body, if we had a town, city, village that had an issue that was operating their own non-metallic mining pit and they had a problem with the discharge, we would have to also issue a notice of claim to them. At the enforcement conference, you're generally going to see your program staff that you work with in the field. You're going to have your EE specialists. You're going to have the principal officers of the facility that was violating or potentially violating. You can bring your attorney. You can bring your consultant. Freudian slip. You can bring your consultant. Anybody who can help explain what happened. We're going to set a date. We're going to give you a date that the conference is scheduled for, and we're going to encourage you to bring those who can help you explain it. Typically, they're going to be held at one of our offices. At times, we will go out to other municipalities. For instance, I know Clark County, we oftentimes, if we've got facilities over in that area, we might meet at the Clark County Courthouse. Generally, it will be those type of locations.
Deb, at that, you talk about what's good for the violator or the company, I guess, is more appropriate. But can you talk what's good for them to have done prior to coming to that enforcement conference? I mean, if there's a violation that's corrected, you're going to look more favorably. But can you go through what's good to do at that and what's bad to do at that?
What's good, generally, once you get your notice of violation, you've had numerous contacts with field staff already. So the facility is going to have some idea of what's going on, and especially from the notice of violation. So prior to the enforcement conference, it's good, try to make corrective actions, or if it's something that you can't correct completely prior to that time, at least have plans in place. You've gotten a hold of a consultant that's able to develop plans for runoff management, for controls, whatever you need to correct it, and bring those in, because that does show proof or provides proof that you're making an effort to resolve the problem. And yes, that does, that helps. I mean, that shows us that you're trying to resolve the issues versus looking at it and just saying, you know, sorry, I'm just not going to work with you. Bring that information in. That's very helpful.
Right, now, what's the bad thing that you've probably experienced over some time? What not to do? You probably got.
Don't bring your grandkids.
Yeah. What not to do? Probably one of the biggest things is don't come in angry, totally angry, and not ready to sit down and discuss. It's very difficult when you have that person. It's very understandable that you're angry that you're getting this letter that says you've allegedly violated these things, and maybe you feel that you didn't. But coming in and sitting down and pounding your fist and yelling at us generally is very counterproductive. We don't get anywhere by doing that. I think I've only had one time that I was about this close to walking out after being yelled at for the first half hour. And we were just about ready to get up and leave, and they finally calmed down enough that we could actually talk to them. So keep in mind that through the enforcement process, even at that point, we're still trying to work things out in most cases. Now, there are cases where even at that point, we're not going to be able to work things out because the situation was so egregious. There was damage to the environment, there was damage to people's health. When we're looking at those situations, we're looking at places where we need to actually take further action. We need to look at going to prosecution with Department of Justice and getting forfeitures for the violations. So there are those situations that we're going to move forward, and we have to. Use of an order, set a schedule for action. We can look at permit revocation. I can't think of any time where I've been involved in an actual permit revocation, but that doesn't mean it won't happen. Ginger, you've been a little bit longer. Have you ever had a permit revoked?
I have not had a permit revoked. I have had someone's license revoked.
Okay.
An operator, a public water supply operator's license revoked.
Okay.
Permit revocation, boy, it usually ends up falling on a person that did something, and so then it depends whether they're certified and things like that.
Yeah. So generally we don't get to that point, but it's not saying that it wouldn't happen. I think I already went through, well, types of orders. We have the unilateral administrative, which I went through before. Administrative forfeiture orders are only associated with public water supply. Now, since we're getting some of these facilities that are becoming, falling into the public water supply realm due to the number of people on site, the number of workers, that would be a possibility. For instance, if you are not providing a safe water supply, and please tell me if I'm not getting this right, Mike. If you have a water supply that is high nitrates, and that's not being addressed, if you have bacteria problems, those type of things in a public water supply, we have the potential for administrative forfeiture orders, and with those, we can actually assess forfeitures right with the order, where in most cases, forfeitures are only assessed through the district attorney's office or Department of Justice. All right, Mike's nodding his head, so I did that correct. Consent orders I already explained. Emergency orders are going to be situations where we have something that needs to be corrected, and we need it corrected right now. We haven't done too many of those. I don't think I've ever done one. We don't use them too often, but if we need to, that is a tool that's out there. Referrals, the place that nobody wants to go, but it does happen. It is a recommendation by the department to prosecute for violations, and these are not random decisions. It starts at the level from the environmental enforcement specialist working with the field staff, going through the violations, talking to their supervisors, making a recommendation up to the regional level, then it goes to Madison, it goes through numerous folks within Madison for review before the recommendation is made and sent over to the Department of Justice. So this is not something that's done on the spur of the moment or because somebody is upset that they did a field inspection and these guys just were not cooperative. Decisions are not made that way. The referral goes through many levels of approval before it goes over to Department of Justice. And then Department of Justice has the option to also look at it and say, we don't feel that this is something that we're going to be able to prosecute. You don't have enough information. They can throw it back at us and make the decision to not refer. And I can see Buck's ready to ask a question.
Yeah, it seems like you're getting more and more when the referral goes to the Department of Justice, naming individuals as well. Is that a policy decision or is that a case by case or?
That's case by case.
That's case by case, and generally it's through discussion with the Department of Justice based on the facts within the case.
And so what can people do? I mean, it's bad enough to go to the Department of Justice with a company. What can they do from your perspective to avoid having them named individually as well?
Well, I don't know if I can answer that one, Buck. Yeah.
I mean, not screaming and hollering at you for half an hour would probably be a first start.
Well, generally people don't get named individually for those things. I guess maybe the thing is that you don't want to be the facility manager out there that says, you know that barrel of oil, that waste oil that's sitting out there, go dump it in the pond. I'm telling you that you have to do that. So I guess that would be one thing. If you've got somebody who is on site that is directing people to do illegal activity and the proof is there that that's happening, yeah, you're looking at being named individually because you are controlling that activity and commanding it. So I think that's one of the things.
What about a history of violations? You had 18 enforcement conferences and they still, you're still back there again.
I hope we wouldn't wait that long, Buck. Yeah, history certainly plays into it, and you know, we've got facilities that you go back in history and we've referred them, they've paid us, you know, hundreds of thousands of dollars in forfeitures, and they're back at the table again. History certainly plays into it, and your level of cooperation. So you want to look at those things, take that into consideration. We're really not bad folks to work with most of the time. We're not trying to catch you. We're not trying to get you into enforcement. We're trying to keep you in compliance. So if you get a enforcement history, yes, that's going to play into our decisions. But bottom line still is, we have to have proof of the violations. Who prosecutes? It can be Wisconsin Department of Justice, it can be the local district attorney, or it can be EPA. Most of the time, it's going to be done in the county courts. We do have the ability at times to request that it removed from the county if there would be some specific reasoning to, but we don't see that happen very often. Maybe more so if we have, I've seen it in situations where we've got multiple violations from one company from various parts of the state. So then rather than trying to prosecute in each of those counties, we'll pull it into Dane County and centralize it. When you're dealing with Ginger and I, you're dealing at the civil level.
Just one thing on EPA, or if you have the U.S. Department of Justice, if you have a Lacey Act violation or something under federal law, sometimes you'll also end up in federal court and deal with the federal DOJ, not Wisconsin.
Correct. Probably a good example is if you're dealing with wetland issues where you're dealing with the core jurisdiction and state jurisdiction. We can actually, we can do parallel actions, but most of the time it'll be taken over by the federal EPA and done at the federal DOJ level. We don't see it too often. I know of one in the state that is going on right now, but you know, most of the time it'll be done at the state level, but yes, especially in something like the wetlands issues.
Just
Go ahead, Tom.
Just want to make one comment on EPA. There are some programs in the DNR that they have oversight over, the air program probably being the biggest one. If you're a high priority violator, the EPA, the process you go through to determine that. If you are, EPA will come in and say, DNR, you have to sue these people. If you don't do it, we will. So we might be put in a position where we don't necessarily think, for just our violation, we might not refer it, but we take it on anyway, just so they won't overfile. We don't want Wisconsin companies having to go down to 230 South Dearborn and end up being in federal court. So I don't want to call it a friendly referral. I mean, there's a better term, but you would rather deal with us in those circumstances than having to go down and deal with the US EPA. So that happens, it has happened quite often.
Yeah, in the air program especially. So generally, if you're dealing with Ginger and I or other EE specialists, you're looking at the civil level. We do have the option to look at the criminal, which is looking at willful and negligent. Generally, those are going to be handled through our environmental wardens or in conjunction with the conservation wardens. It's pretty amazing I've been with the agency for 23 years, and to see the change in the role of the conservation wardens from fish and game to the environmental realm, and how much they do now as far as assisting in the environmental law is pretty amazing. And if you talk to them, they'll tell you that their bigger cases are generally the environmental cases versus fish and game. And they do have the realization that if it wasn't for the environmental cases, the protection of fish and game would not be done either. So they've become a pretty intricate part of our environmental law group. This is actually a picture, the next step from the last one that you saw, and that is going out into the St. Croix River. And that's it. Questions?
I want to raise just a couple other things. Tom already raised the issue of memorandums of agreement with US EPA. That's how state gets some of their funding, but we've also made sure that the state is, let's call it, in compliance with federal requirements. So it's very critical that they do understand that there are certain violations that no matter what, we are required to end up doing a referral. And if we don't do it, the feds will. One of the things to your benefit is to, if you get that, as early as possible when you realize there's a violation, step up to the plate and start correcting the problems ASAP, keep all your documentation as to what you corrected. If you do get referred, it does help keep your penalties down. Because you are working with us, but there may be times where even if you do everything right after the accident, we may have to seek a penalty. Buck asked a question on some of the things as to if you're invited to an enforcement conference, what not to do. Don't be a no-show. If we send you something and it has a date and you can't meet that date, pick up the phone and call me and say, I can't meet that date. We will try and reschedule it and meet your needs. Usually the date we're giving you is something that we've tried very hard to coordinate. We've got to coordinate with our field staff and everybody else's calendar also. So we picked those dates because our end can make it. But we realize that, and we're trying to we usually give you 2 weeks from when we're sending that penalty to try and set your schedule, and hopefully you can work it in. I've had people that continually reschedule and reschedule and reschedule. That's what we don't want. Avoidance isn't gonna solve the problem, so don't be a no-show. You know, we'll try and work with you on making it so you can show. I answered that one. Okay.
One of the things maybe both Ginger and Deb can comment on is, it seems like 10 years ago, we used to get more supplemental environmental projects where we would sit down at enforcement conferences, and now DOJ is dead set against doing them. I've done one in the last 5 years. But what are your comments on that? I know you have to follow the regulation, but they're supposed to go beyond the regulation, and it seems like some of those help get companies in compliance.
My understanding is that that is a administrative decision at the Department of Justice. We've had discussions about the steps being available, and every time it's that the administration doesn't want to see them. So, I guess I'd encourage you to make the comments to the Department of Justice that you'd like to see them come back.
I have. Ginger, do you have any comment on that?
No. It's just, it's being discouraged, and
I think it's a mistake on DOJ's part, because if you're going to be able to spend the money, I mean, I know the money goes to the government, and we're all supposed to be happy paying the government. From a company's point of view, it's much better if you're using that money, even if you're spending a little more, but getting some benefit and protecting the environment. So.
Well, I think too, it doesn't come back into DNR. The money goes into the school fund, if I'm not
Correct.
mistaken.
Yeah.
So, it's not that we're seeing it come back to the environment. And I don't think we would argue that we wouldn't like to see at least some of it come back to do environmental projects. But it's not our decision, unfortunately.
Other questions? At this stage, we've got some discussions. If anybody has any questions, but if people want to get home early, I don't think we have any problems with that, Deb.
No, or if there's any topics that we didn't cover, if there's any suggestions of things that you would like to see more information put out on, or things like that, those are the things that we need to know so that we can get the information out there.
Just, you might want to talk about the, the video being available in a week or for those who got here late.
Yeah, again, thank you to the two law firms. They have made arrangements so that everything would be videotaped, and it's going to be edited and then put out. I think you guys are both putting it out on your websites. We're going to try to get it put out on the DNR website, along with having the PowerPoint presentations available. The other thing, which I'm going to do after this, is I'm going to try to make a consolidated list of the resources that can just be put together and maybe emailed out to the distribution list of everybody that attended.
And we'll also try to put it on APW, which is Acre Producers, and probably Industrial Sand will get it to Bill White, and WTVA will probably put it on their website as well.
Yeah, and again, communication, communication, communication. Call and ask, and even if you're not sure, call and ask. That's the easiest way to avoid having problems.
And I'd just like to thank Deb. This was kind of her idea to get everybody together, and she spent a lot of time and effort getting it pulled together and getting it done prior to the season starting. And she's the reason that it snowed so long, so we can get here.
No.
Thanks, Bob.
Thank you.